Hi, good morning. We are happy to have you join us for this special student data privacy webinar. We have Tanya Albornoz here from Dcfs, and this is a presentation very similar to the one that she gave in November, right? And it was a highly rated session. Folks found it really helpful, but not everyone was able to attend one of those two sessions and asked if we could provide this webinar. So without further ado, I'll turn the time over to Tanya to provide the webinar. I will be looking at the chat. If you have any questions, please write your questions or chime in, and we'll address those right away.
Yeah, sounds great. Thanks, Whitney. So I have a lot of information to cover today, so I will probably go fairly quickly. I am, like she said, Tanya Albornoz. I'm the DCFS Administrator for Foster Care and Community Programs. And I've been at the state office for about 12 years for DCFS. So I've been in this position for quite a while. And one of my main duties is to work with schools and education to make sure that our kids are getting appropriate education services. So really quickly, I just wanted to go over a list of agencies that are within the Department of Human Services. Child and Family Services and Juvenile Justice Services are the ones that probably everyone is most familiar with. We also have what's called Systems of Care. Some of you may have heard of that. Those are the three main agencies that are most likely to be involved with schools and requesting records, and so I wanted to make sure to mention them. The others on this list are the other main agencies that are located under the umbrella of DHS. DCFS, I'm going to be speaking mainly about DCFS today, and then at the end I'll touch on JJS and Systems of Care a little bit in regards to record sharing with them and what you can and can't do. Our number one goal at DCFS is that children can remain safely in their homes with their parents, if at all safely possible. So we have been working on an initiative called Homeworks for about the last 6 years, where we focused more on providing in-home services for families. So if we have an allegation of abuse or neglect come to us, we do an assessment to see if the child can safely remain in the home. And if they can, then that's our preference. However, if they can't remain safely in their home, then our next goal is to make sure that we support those children who are removed and that we help them to attain legal permanency. So our goal would be to either reunify them back with their parents or to provide them with permanency in another family setting, like an adoption or with a relative. Our philosophy is that kids need to be with families, so whether that's with their own family or another permanent family, that's our goal. DCFS has a list of services that many people aren't aware of, besides foster care and child protective services, which are the ones that you're probably mainly familiar with. We also are the pass-through agency for prevention funding for the state. So the state receives federal and state funds for child abuse prevention services, which includes funding to support the family support centers and the partnership with Prevent Child Abuse Utah, and we're the pass-through agency for that, so we administer those programs. Child Protective Services is the investigation arm of DCFS, and they're the ones that go out and investigate allegations of abuse or neglect. We have in-home services, which many people are not aware of too, where we work with children who remain in the home with their families to connect them to services in the community. Those are children that might be at risk of removal from their home. That includes services that you might know as family preservation services. Then we also have domestic violence services. We're the pass-through agency for domestic violence funding for the state as well. So we receive the legislative funds to administer domestic violence shelters. And the last set of services is known as out-of-home services, and that includes children who are placed with relatives, that are placed in foster care, and that might be adopted. We also have a set of services called Transition to Adult Living, which are provided to children who are 14 and up in care so that we can help them build the skills that they need to become successful adults. And post-adopt services support families who have adopted children from foster care or from other countries. So we do have a set of services that provide support and can provide referrals and treatment services for post-adopt families who have adopted. Just really quickly, I wanted to go over a few key things about child abuse reporting. Utah has a mandatory law that anyone with a reason to believe must report child abuse or neglect. So if there's any suspicions or any concerns that there might be child abuse happening in the life of a child or a student, you are required to report. Educational staff are our highest reporters, so it's about 17% of our reporters, and that's the highest category. The next highest category would be like medical staff. So education staff are really important in helping monitor the safety of children, and just want to reiterate to you that if you have any suspicions, the CPS hotline number is right there, and you can call those referrals into the hotline. We get about 65,000 calls a year. We have a dedicated line for professionals that's available 24/7, and the average wait time for that is about 30 seconds. So if you call in a referral, hopefully our goal is that you're not waiting very long. A lot of people have questions about what happens once a referral is called into the hotline, so I wanted to quickly review what happens when we receive a referral. So when the intake receives an allegation of abuse or neglect, they have a decision instrument that they use, an assessment that guides them whether or not they can open the case. So there are requirements in the law that the allegation has to meet in order for us to be able to open an investigation. So when that call comes into CPS intake, the intake worker makes the decision using that decision tree whether or not they can accept it for investigation. So the decision is either to open the case or to unaccept the referral. And that just means that there wasn't enough information to meet the criteria. Once they make a decision to open the case, then they will assign it a priority. We use a priority in order for our caseworkers to know how quickly they need to respond on this allegation. A priority 1 means that they have a 1-hour response time, and that means that there's an imminent risk or no adult available to take care of the children. So an example of a priority 1 referral might be when law enforcement is on scene and they're arresting the parents and they're unable to locate anyone else who might be appropriate to care for the children. And usually that happens when there is law enforcement on the scene. A priority 2 is that a CPS worker has to respond within 24 hours. This might be when a child has marks or injuries and we need to document that, or the child is in imminent danger or saying that they're refusing to go home because they don't feel safe. You might be familiar with priority 2s. That's what happens a lot when the school calls in an allegation. Usually the CPS worker tries to get there that same day so that they can document any injuries. The last priority is a priority 3, and that is that caseworkers need to respond and interview the child by the end of the 3rd business day. And that's usually all other investigations, and another one that probably happens when you call in a referral. So the priorities, again, are really just that's the time frame that a CPS worker has to respond and interview the child. So once CPS goes out and investigates, then they have 30 days to conduct their investigation generally. They collect evidence from, I'm going to lose my voice. They collect evidence from everyone that's involved in the case, including they have an obligation to speak to you if you're the referent, if you're the one that provided the referral. They speak with all the children involved in the home. They have an obligation to speak to the parents at some point. They are required by law to keep the identity of the referent anonymous. However, sometimes the nature of the information that you provide may lead the family to deduce your identity, but CPS workers are well trained that they are not able to provide the name of the referent. So a CPS worker conducts the investigation, and they decide if the case is supported by the evidence that they have gathered or not supported by the evidence that they've gathered. Without merit is another category that we use in the event that the completion of the investigation, they make a conclusion that the alleged abuse or neglect did not occur. So those are the categories that happen at the end of an investigation. CPS workers are required by law to inform the referent just that the case is closed. We are unable to generally share the results of the case. So many people have questions about that. And then CPS, if they support the case, they have a choice to either open a case for ongoing Dcfs services, which include those in-home services or those out-of-home services that we talked about on the previous slide, or they can close the case and provide community referrals to community services. Are there any questions about that? No? Okay. Also, if there's questions at the end, I'll catch those too. So I'm going to give you some key statistics. This is based on our 2018 statistics. Just really fast, I wanted to let you know a little bit about the agency. We get about 41,000 reports or concerns of child abuse or neglect a year. We only open about 21,000 of those to do investigations. And of those 21,000 that we open, only 59% are unsupported by the evidence that's gained during the investigation. And 35% of those referrals are supported. Of those cases that are supported, 81% of those families are referred out to community services. So that's a majority of the cases are referred out to services in the community, and we don't have ongoing services. 17% receive in-home services, so we have a caseworker that works with the family in the home while the child remains there, and only 13% of child victims are removed and brought into foster care. Of those kids that are investigated for abuse or neglect, 94.7% of those children do not experience repeat maltreatment within the next 6 months, which shows us that we're doing a pretty good job of being able to determine when a situation is unsafe for a child and when we need to provide ongoing services. 42% of the children that are removed are placed with relatives. So a majority of our kids go to relative placements. And over the year, last year in 2018, we served 4,728 kids in care. And that number remains fairly stable, has remained fairly stable over about the last, I'd say, 7 years. So when it comes to permanency, this is in regards to children who are in foster care. We first look at relatives for placement. The very first person we look at has to be a non-custodial parent. And then we look at a relative, and we use an unrelated foster family as a last resort. Of those kids, the majority of them, 41%, are reunified with parents at the end of a case, which means that the parents have been able to show or demonstrate that they've made concerted efforts to have the children returned to them and that their environment is safe for the child. 30% of the kids go to an adoption, and that can be an adoption with a relative or with a foster parent. 16% go to custody to a relative, 8% age out of care, and that's the one that we don't like and we're working on, and 2% of those kids are given custody to the foster parent. The other category has to do with kids that may go to juvenile justice services or run away or that are referred outside of Dcfs. So just to reiterate, the vast majority of these kids are returned home to their parents. So now let's talk a little bit about improving educational outcomes for these kids in foster care. So first of all, how do our students perform? And this is based on a study that it's a little bit older. It was done in 2012 or 2013. We're working on getting these numbers updated. So just be aware as I share these numbers that they're a little bit older, and they're probably a little bit lower than what we would see today. So only 3 to 9% of our kids that are in foster care receive college degrees, and that's a pretty dismal number. That is something that we've been working on for a number of years. We are hoping that number, when we do the follow-up study to this 2012 study that number has increased by quite a bit. But 67% receive high school diplomas, and of the kids in foster care, 40% of them are moving quite frequently from school to school. So that mobility rate is showing that kids in foster care, 40% of them have a high mobility rate. That means they've been in 3 or more schools during their year. This study showed that 36% of the kids in foster care receive special education services. I think that now that number is probably closer to 40 from the statistics that we've recently looked at. So on average, our kids have about 8 schools during their time in foster care, which is pretty alarming because every time a child moves, they have a 4 to 6 month academic delay. So this is something that we definitely have been working on with our caseworkers. There are some system constraints, but philosophically, our belief at Dcfs is that they should be remaining in schools if at all possible, and we'll talk a little bit more about that in a minute. I just want to quickly talk a little bit about how trauma affects learning. So when children are in foster care or involved with Dcfs, you can safely make an assumption that they've experienced some kind of trauma. Just the trauma of removal from the home itself is enough to affect the learning of a child in school. So kids in child welfare all experience extreme trauma, which can then affect the relationships with their teachers and counselors as a result of being uprooted and those relationships that they had in their life being destroyed over and over again and not having a routine that they can count on. These kids wake up every morning wondering if they're going to move to another home that day. That ongoing instability creates further stress, and it's really hard for these kids who are experiencing the stress to be able to learn and be creative, and they're expected to do that in the school, and sometimes that's really hard for these kids. So cognitive and emotional functions become focused on coping and survival. They're stuck in that fight, flight, or freeze mode. And a lot of times the behavioral problems that you see with these kids are related to the trauma that they've experienced. So the question that education staff should be asking is not what's wrong with a child that's been in foster care or that's been involved with Dcfs, but what has happened to them in their lives. It's not about their behavior. You should assume that it's really about the trauma that they're experiencing, the instability that they're experiencing. And the trauma, we also know that trauma affects learning and has an impact on the brain. So the question that we should always keep in mind is, can this child be focused on learning when they're trying to survive and deal with that trauma? So having talked about all of that, let's talk a little bit about how we can then increase the success of our kids in foster care. So one of the things that our kids need is education stability. And as I mentioned, we have been spending a great deal of time trying to train our caseworkers about the need for these kids to remain in their school if at all possible. And that means remaining in the school that they were attending prior to their removal from the home, as well as when they are in foster care, if they can remain in the school that they're attending, even if they have to move foster homes, then we try to do that as well. Education staff need to be aware of those trauma issues that we were just talking about on the previous slide. They need more attention from teachers and a positive environment. When it comes to future planning, lots of these kids cannot see a future for themselves. So it's really important for everyone involved in their life to help them plan for their future and make goals for themselves and see a possibility in the future. These kids need to be able to work at their own pace. They need to have an assessment for special ed if anyone on the team suspects that they are eligible for special ed services. They need to have access to resources and technology. They need to have people who are aware of their credits, their progress towards a diploma, and they also need to be placed in the least restrictive environment, which is a huge deal for our kids in foster care. One of the biggest things I wanted to mention to you today on the webinar is that many of our youth who are in foster care state that their status as a foster child is not kept confidential, and this often results in stigma towards them, and especially from other students and from teachers. And so one thing we can do in the schools is to keep their status as a foster child confidential. If a caseworker comes to visit the child at school, for example, not calling them down to the office to see their caseworker would probably be something that would be a really good thing. And lastly, timely record transfers when they do have to change school. So we are making efforts, like I said, to maintain their school, but there's many times where they have to transfer schools, and when that happens, if we can assist with that timely records transfer, then they won't be losing credits and things of that nature. So in child welfare, within DCFS, we have a practice model that we operate under, a philosophy, and teaming, child and family teaming, is a core principle of that framework. Every case has a child and family team that's supposed to be meeting regularly, and all case decisions are made within the context of that team. So important issues are discussed, and that's where decisions are made about the case. It includes everyone involved with the child and family. So this should be including counselors or education staff, teachers, special ed staff, whoever can represent the education needs of the child. Anyone who's on the team can request a meeting at any time. The reason this is important for you to understand in the schools is that if a caseworker is considering moving a child to another school, then the school has a right to call a child and family team meeting to discuss the possibility of maintaining that school placement in that school, or even talking about, well, maybe we can wait a few weeks till the end of the quarter where those logical transition times are, so that the child can, all the progress that child has made over that school quarter can go with them if they have to move. Okay, so now we're going to get into a little bit of the federal and state legislation for education needs of students in care. So the federal legislation that governs child welfare requires that all children in foster care are full-time enrolled in education. It also allows for a child to remain in the school, as we've been discussing, and there's also a state statute, which is 53A2207, which allows DCFS to enroll a child in any school that we find to be in the best interest of the child. So the state statute gives DCFS the ability to enroll a child in a school regardless of where they're living. The federal legislation also mandates efforts to maintain school placements and education stability, and that's the one that we've been talking a lot about. That's federal statute was called the Fostering Connections Act, and it was passed in 2008. It also requires immediate enrollment of school if a change is needed. So if a child does have to remove schools, we have made it a policy within DCFS that has to happen within 3 days. And the federal legislation also gave DCFS the ability to provide a travel reimbursement to foster parents if they want to provide transportation of the child back to the school that they were attending. So we do have mechanisms within DCFS where we can provide for reimbursement for mileage for foster parents to transport the child. Okay. Again, I've already mentioned this several times, but it's DCFS's policy that active efforts will be made to minimize school disruptions and facilitate timely enrollment when necessary. Again, this is best practice, and this is our policy. I do want to emphasize that we have a lot of turnover among our caseworkers, and so having education be aware of this as our policy and helping our caseworkers understand this is an important part of this for us. Caseworkers sometimes forget, and they think that when a child has to move a foster home, then they'll automatically just enroll them in a new school. And if we can have your help in helping caseworkers understand that it's important that they remain in their schools, then that would go a long way to helping us achieve this and minimize school disruptions. Court attendance is the only exception to this minimizing school disruptions. There is a state statute that foster children are required to attend their court hearings. So we have tried to train caseworkers and foster parents that they should get homework and assignments beforehand, before the court hearing, so that they can make that up. And again, DCFS policy states they have to be enrolled within 3 business days of coming into custody or moving foster homes if a change is necessary. So that's the timely enrollment piece. All right, let's talk a little bit about data sharing, probably a main reason why we're doing this today. So in 2014, the Department of Human Services, the Juvenile Court, and the State Board of Education formed a partnership, and we had an MOU that was signed by all 3 agencies that education information could be shared for youth in custody. In 2016, in the legislative session, that was made into law. It means that there's no FERPA restrictions to sharing information between agencies when it comes to children in foster care or involved with DHS. We use the information that we gather from the schools to inform the child and family team that I mentioned earlier about education decisions for that child, and also to fill out what the courts have mandated, which is an education court report. Some of you may be familiar with it. It's a form that the judges require at every court hearing to gather education information about the child and their progress and other things related to their education. So when you receive a request for information from a DCFS caseworker or from a juvenile justice worker or from a systems of care worker, all DHS employees have identification badges that you can ask them to provide you with when they're requesting education information. And you can, if they're requesting the information electronically, you can request that they send you a copy of their badge so that you have that for your records. So this is the actual data sharing statute. It's 53E9308. And I've included the language from it here on this slide so that you can look it over and see that a student data manager may share students' personally identified student data with a caseworker or representative of DHS if those conditions apply. So again, DHS is a custodial agency. They are legally responsible for the care and protection of the student if they're in foster care, and so you're able to share that information. Also, we're able to share that information with the juvenile court in order for them to improve education outcomes and monitor the educational process or the educational progress of a child who's in foster care or involved with DHS. That includes DCFS, Juvenile Justice Services, a DSPD student, or any child under the jurisdiction of the juvenile court. And that distinction is important for you to understand when it comes to probation officers. Probation officers work for the courts. They don't work for DHS. And so this statute also provides them with the ability to obtain student records. Questions about that? I want to pause there.
So hard.
Okay. When it comes to Child Protective Services, these are the investigators that come out to the schools to do the investigations for child abuse and neglect. There is a specific statute for them. That school personnel shall cooperate with DCFS and share all information with the division that is relevant to the division's investigation of an allegation of abuse or neglect. So this is the statute that states that schools can and should cooperate with CPS investigators when they come out to the school. CPS investigators sometimes need this information. They will look at the emergency contacts on the card sometimes, especially if they know they're going to do a removal. It might be them looking at that card to get information for possible placements. They could also be looking at the school information if it relates to the investigation or to the allegations that we've received. So just make sure that you're cooperating with our CPS investigators and providing them with that information. Again, it's not a FERPA violation if you're sharing the records with them. Okay, I want to talk a little bit about special education too, because our kids with the high mobility rate and with special educations being held in a separate location from the student file, it's just really important for us to have considerations around these special education issues. Knowing that there's a high prevalence of our kids that are involved with special ed. We talked about how 36% of them in foster care qualify for special education services. I do think that number is slightly low. I think it's higher than that. But As I mentioned before, anyone should request an evaluation if you suspect that there's a special ed need or if they might qualify. And what we've invited schools to do and data managers to do is just to assume that if you receive a records request for a student that's in foster care, that you just make an assumption that there's a special ed file associated with that child. Or like if you're making a request to another school or if you're receiving a request, just assume that there's a special ed file and make sure to accommodate that piece when you're requesting records. Also, make sure that parents, foster parents, and caseworkers are invited to IEP meetings. I just want to mention here that because a caseworker is a representative of the state, they cannot sign as a parent on the IEP. They can sign as a participant, but they can and should be involved in the IEP meetings. Who can sign as a parent is a biological parent, a foster parent, or the surrogate parent as designated by the school district. That's a confusion. That's a question that we're always getting at Dcfs. So I wanted to make sure to mention that. Let's see. So quick reiteration about parents here. If there is not an order, a protective order in place or a no contact order in place against that parent, they should be invited to all education meetings. So we should be inviting them to parent-teacher conferences or IEP meetings so that they can have involvement in those. Whether or not they show up, that's up to them. But if parental rights are still in place and if there's no safety concerns, then those parents should definitely be included in any school meetings. So, all right, now we'll talk about what caseworkers may share with you. So anything relevant to the education services for the child and the safety of the students in the school and for the student in foster care, they can share that information. They can share knowledge regarding past education placements, and they can share past education records. They can also let you know whether there's a protective order, no contact order, or other safety concerns regarding the parent or guardian of the child. And again, that's important because they need to be invited to school functions if there is no safety concern. What they can't share, though, is information or allegations regarding the parent or guardian that the child was removed from. So we have to be really careful that we're protecting the confidentiality of the parents and really careful about the information that we're sharing with you in regards to those initial allegations that brought the child into custody. Information about the case that's not relevant to the child's education, we also have to be very careful about sharing. When it comes to psychologicals, sometimes those are requested as a part of the special education evaluation. And when it comes to psychologicals, we have worked with USBE and with our attorney generals to determine that requests for psychologicals have to come through a grandma request to our agency. We can share the psychological with counselors, school social workers, anyone who's a licensed mental health professional, but we can't share it with just like the special education team or the teacher. So those will have to come to DCFS, and I believe that USB will be putting out some information about how to request those psychologicals if they're needed for special ed. And that's because many times the psychologicals contain really sensitive information about the child and family. That doesn't necessarily apply to education. Okay, so I mentioned that we have in-home cases that we often work with families when the children can remain safely in the home. These cases are a little bit different from foster care cases in that we can't identify that we're even working with the family unless the family signs a release of information. So we have to have the parent or guardian sign a release of information, or we have to have a court order stating that we can get education records for a family that we're working with on an in-home basis. We are required to turn in the education court report for families that we're working with on an in-home basis. Often we'll have the parents try to gather that information. If the parents don't want to, then that's when we will get a court order to get those school records. Education staff may be invited to the team meeting with prior permission and consent from the parent guardian if we're working with them on an in-home case. And usually that happens when the allegations have something to do with education of the child. Okay, what educators can do, we've already mentioned a few of these. You can provide input or be included into the child and family team meeting. You can keep in contact with the caseworker and the foster parent for a child in foster care. That foster parent living with the child on a daily basis knows their needs, knows their behaviors, and can help the school understand the needs of the child. When information is needed from Dcfs, my advice is to prepare a written statement clearly communicating the rationale for the information, why you need it, the purpose, what the information will be used for, and why it's relevant to the child's education. If a caseworker has a prepared written statement like that, they'll be more likely to share the information because they know exactly what you're going to do with it. Our caseworkers are often like education staff in that they are very dedicated to their responsibility to maintain the confidentiality of the kids in foster care, and so they're really careful about records requests as well. Request that the caseworker respond back to the information in writing, and also you can assist us with the timely record transfers when a child needs to change schools. So those are some things that education can do to assist us with these kids in foster care. Okay, for districts that have youth in custody programs, we have at the state level a Utah Coordinating Council for Youth in Care. It's an advisory council to the State Board of Education, and we discuss the funding for youth in custody programs and the best way to disperse those funds to support services for students in the school districts. We look at evidence-based research and practice and recommend changes based on them and approve the funding requests from the school districts on an annual basis. Members of the council include Dcfs, JJS, juvenile courts, substance abuse and mental health. We have a superintendent on the council, as well as tribal representatives and representatives from the State Board of Education, including special ed. So the reason this is important for you to understand is that there is a line item dedicated to education services for kids in care that funds a lot of the school services. So if there's a need, please make sure that you're coordinating with your youth in care or youth in custody program staff that are in your school district, and also make sure that we have DCFS has a policy that caseworkers are required to enroll a child in YIC if there's a YIC program in the district. Something that caseworkers often forget to do, especially if they're younger or in elementary schools. So one thing you can do is, if you're unsure or positive that a child is in foster care and they're not enrolled in the youth in custody program, we want them to be, because they can receive the mentoring services that are provided through youth in custody and other services to support their education. Again, there's the education court report is another thing that that's being worked on by the council, the coordinating council for youth in custody. So we're making some modifications to that, and we guide the policy of youth in custody programs. All right, so take a moment to see this map. It's the districts where youth in custody programs exist. So if you are in one of these districts that are pink, you have a youth in custody program in your district that you may not be aware of. So just take a moment to look at that. Also, another resource that's important for you to know about is that we have an Educating Youth in State Care website that has a lot of information, including the map that I just showed, so that if you need to contact someone, it shows all the contacts for the YIC programs in the districts, as well as the DCFS contacts, the JJS contacts, and the court contacts for each of the school districts. So you can find information on this website. It also has a frequently asked questions function, where many of the questions that you have about youth that are in either JJS or DCFS custody you can get answers to those questions. All right, so Dcfs is broken down into 5 regions statewide. This is how we're set up. We're administered by the state office, but each region also has their region administration. So take a moment to look at this slide and find the county that you are in, and then you'll know what Dcfs region that corresponds to. And the reason that this is important is because each Dcfs region has a region education specialist that you can connect with if you're experiencing any kind of education issues on a child who's in foster care. So the next slide is the name and contact information for each of the education specialists in the regions. Some of you may be aware of or familiar with them, but if you're experiencing any sort of issues with a child in foster care or that's working with Dcfs regarding education, these are your first line of defense contacts. So contact this person, and then if you're unable to get the information that you need, they will help facilitate the contact with me or with the State Board of Education. So I went way faster than I thought I would, but here's my information. Again, my name is Tanya Albornoz. I'm the Dcfs Administrator for Foster Care and Community Programs. I am always available to you for your questions. My email is right there. I'm in meetings often, so the best way to get a hold of me is through email. And that is all I have, and I'm wondering if there's any questions.
So we can wait for any questions. In the meantime, I wanted to send everyone a copy of our Utah Student Privacy Guidebook. And if you look at page 28, there'll be some more details written about sharing information with caseworkers and the redisclosure of that. This is a FERPA exception that is permissive, and you can see in Utah state law that it is supported for the data sharing. I spoke to a district principal recently who said that their policy was that they wanted to see not just the badge of the caseworker, but some kind of document verifying that they're working with a particular student. That's a local policy decision that you can make. It doesn't just need to be the badge, although I think that's usually sufficient.
So they have a badge, but they also they can provide you with a court order which states that the child is in custody, or they also have what we call the school enrollment letter, which is provided to foster parents when we place a child in their home, so that they can take that letter and enroll the child into school. And that should serve as sufficient evidence to show that we're working with a child.
So I don't see any questions, I think, because you explained it so well. If you have follow-up questions, contact me or Tanya, and we'll get you the right answers. Our next webinar will be the first Wednesday of April. That's April 3rd at the same time. So we're going to end a little early today. Have a great day.
Okay, thank you.